The first 10 amendments of the Constitution make up the Bill of Rights, written by James Madison because several states wanted more constitutional protections and individual liberties. The Bill of Rights lists specific prohibitions on government power. One of the many points of contention between Federalists and Anti-Federalists was the Constitution's lack of a Bill of Rights that would place specific limits on government power. Federalists argued that the Constitution did not need a Bill of Rights because the people in the states kept any power not given to the federal government. Anti-Federalists held that a Bill of Rights was necessary to safeguard individual liberty. Madison, then a member of the U.S. House of Representatives, went through the Constitution himself, making changes where he thought were most appropriate, but several representatives, led by Roger Sherman, objected the idea and said that Congress had no authority to change the wording of the Constitution itself. Therefore, Madison's changes were presented as a list of amendments that would follow Article 7. The House approved 17 amendments. Of these 17, the Senate approved 12, and of those 12 that were sent to the states for approval in August of 1789, 10 were quickly approved or ratified. Virginia's legislature became the last to ratify the amendments on December 15, 1791. And the Bill of Rights was largely inspired by English documents such as the Magna Carta, the Petition of Rights, the English Bill of Rights, and the Massachusetts Body of Liberties. The First Amendment states that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the land or naval forces, or in the militia when in actual service in time of war or public danger, nor shall any person be subject for the same offense to be twice put in jeopardy of the right of the people peaceably to assemble and to petition the government for redress of grievances. They're basically saying, detailing the freedom of religion, press, expression, all that was listed in the Constitution before. Amendment 2 says, a well-regulated militia being necessary to the security of a free state, the right of people to keep and bear arms shall not be infringed. They're saying that you just have the right to keep a weapon and use it to protect yourself. Amendment 3 says, no soldier shall in time of peace be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. This is kind of referring to the Quartering Act, kind of saying that soldiers cannot take or live in a person's house without permission of the owner, which is why America decided to be independent. But Amendment 4. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue, but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. The Fourth Amendment is basically stating that a person or their property cannot be searched unless there is a probable cause that a crime has been committed, so you can't falsely accuse anyone of anything. And Amendment 5 says, no person shall be held to answer for a capital or otherwise infamous crime, unless on presentment or indictment of a grand jury, except in cases arising in life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law. Nor shall private property be taken for public use without just compensation. They're saying that they need the due process of law before punishing a person, and they can exercise their right to a trial by jury as previously detailed. Amendment 6 says, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witness against him, to have a compulsory process for obtaining witnesses in his favor, and to have the assistance of a counsel for his defense. That one is kind of hard to explain, but they're just saying that overall it's the right to a fair trial and covering the subject of witnesses and how that's handled. Amendment 7 says, in suits at common law where the value in controversy shall exceed $20, the right of trial by jury shall be preserved. No fact tried by jury shall be otherwise re-examined in any court of the United States than according to the rules of common law. They're just saying, again, trial by jury in civil cases and those rights of being sued. So, yeah. Amendment 8 says, excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. They're saying no, like, excessive bail, excessive fines. That one's pretty straightforward. No cruel or unusual punishments. Amendment 9 says, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. They're just saying that America does not include all of the rights of the people in the states, because that's just not really, that's a lot of people. Amendment 10, which is the last amendment, says, the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. This one is pretty much saying that states, it's saying that any powers that the Constitution does not give to the U.S. government belong to the individual states and the people, so that the states have some level of autonomy. The end.